Good morning and welcome to the First District Court of Appeal. We have two cases on the docket today. We will hear them in the order that they appear. Following the first case, we will take a brief recess. Our first case on the docket is R.J. Reynolds Tobacco Company versus Rosina Nelson, Liggett Group, LLC, and Vector Group. Counsel, if you're ready, you may proceed.
Good morning, and may it please the court. My name is Victoria Powell, and I have with me at counsel's table Charles Morse for the appellant R.J. Reynolds Tobacco Company. I'd like to reserve 4 minutes of my time for rebuttal, if that's okay.
So noted.
Thank you. The fundamental ground rules of jury selection were not followed in this case for 3 reasons. First, the trial court did not give Reynolds nearly enough time to conduct voir dire on the second day of jury selection, which resulted in Reynolds being unable to individually question 5 jurors at all, one of whom was seated on the jury and returned a verdict against Reynolds. Second, and to make matters worse, the trial court notified Reynolds of the time limits on voir dire only moments before voir dire began on the second day. Third, the trial court gave Reynolds fewer peremptory strikes than Mr. Gordon, denying Reynolds its right to an equal number of peremptory strikes. As to the first issue, Reynolds has a basic right under Florida law to have an adequate opportunity to question prospective jurors. That right is recognized in Rule of Civil Procedure 1.431b, and as this court explained in the Barker opinion, a trial court abuses its discretion when it cuts attorney voir dire short in a way that prevents further examination that may well disqualify the juror, perhaps not for cause, but for the proper exercise of a peremptory challenge. Here, the trial court violated this right on the second day of jury selection when it gave Reynolds only 30 to 40 minutes to question 31 prospective jurors in a complex case, while allowing Mr. Gordon over an hour. The time limits prevented Reynolds from asking important questions that were not asked by either party, such as the jurors' views on non-economic damages, comparative fault, their views on smoking in general.
Counsel, you make good arguments about due process, but there are multiple failures by R.J. Reynolds to object. Once the jury was selected, there was no objection when they were sworn. So what do we do with the lack of preservation in this record?
Sure, I'll address those in 2 parts. First, as to your question about objecting before the jury was sworn. So here, Reynolds did make an objection at the very end of jury selection. So jury selection ended on page 507 of the trial transcript. On pages 506 to 507, Reynolds objected to the seating of juror 49 on the basis that that juror was one that Reynolds never spoke to and asked for an extra peremptory to remove that juror. And the court denied counsel the opportunity to strike that juror with a peremptory challenge.
Well, I understand you led off your brief with an extensive discussion of the peremptory challenges, and I'm sure you want to discuss that issue, and I can't speak for my colleagues, but I'd like to talk about the directed verdict issue. Where in this record is there evidence that it was 50% more likely, plus 1 iota of evidence, that the appellee contracted COPD in the first 15 years of his smoking history? It's tragic that he passed away. But where is it in the record that an expert testified, yes, but for the smoking of the cigarettes, by 1969, 15 years after he started smoking, he had COPD?
That's nowhere in the record.
I didn't see it either.
That's absolutely correct.
And isn't it true then under Gooding, the 1984 Florida Supreme Court decision, the directed verdict had to be granted?
That's exactly correct. There was no evidence that tied the smoking before 1969, which is under the failure to warn claim, that would be the relevant time period.
And regarding failure to warn, didn't the decedent testify he never read those?
That's exactly correct. He repeatedly testified consistently, unrefuted, that he never paid attention to the warnings, that when he saw the warnings after 1969, he just simply didn't pay attention to them. His testimony was—
In fact, the Surgeon General's warning was out in '64, but regardless, on the record in this case, the failure to warn claim seems almost non-existent.
That's exactly right. There's unrebutted testimony that he did not pay attention to the
In fact, he
warnings.
didn't stop smoking until he got the COPD diagnosis, right?
That's exactly right. The evidence is that no amount of warnings would have made a difference to him. Mr. Gordon was the type of person who,
So-
until he got that
So the
diagnosis.
verdict has to be based on either failure to warn or that he received it through the negligence, the design defect, that he would have had COPD by 1969.
That's correct, and I'm
And
happy
all
to,
I saw was the expert testifying that, well, yes, you can contract it with 15 pack years of smoking. Not, he contracted it after 15 years of pack smoking based on 50% or more, 1 iota of evidence.
that's correct. There was no evidence that he contracted it before 1969.
I mean, feel free to talk about peremptories all you want, but it seems to me that's more the relevant issue here today.
And I'm happy to address the design defect issue too, because the court would need to address the design defect theory as well as the failure to warn theory.
Okay, before we go to design defect,
Yes.
I have a few questions on failure to warn as well. So, you know, it seems that the plaintiff was smoking 1954, warning came out in 1969. How many years after that warning did the plaintiff continue to smoke?
He smoked until 2018, which is when he got his COPD diagnosis.
So for decades of warnings, and again, never paid any attention
That's
to the
correct.
warnings. Is there any evidence in this record that would create a fact question for the jury that in light of his, you know, disregard of the failures to warn for decades, that he would have done something differently in the 1954 to 1969, you know, non-warning period?
I'm certainly happy to talk through the evidence that the plaintiff pointed to. So the evidence the plaintiff pointed to was that Mr. Gordon testified that the day that he was diagnosed with COPD, he immediately quit. I think that again only confirms that Mr. Gordon was the type of person who no amount of warning was going to change him. He was the type of person that needed to be diagnosed with COPD in order to realize the risks. Mr. Gordon also testified that he was a low-risk person. He was a risk-adverse person. That was something that the plaintiff pointed to in opposing our directed verdict motion. Still, even as a person who was risk-adverse, he continued to smoke for decades, as Chief Judge Rowe pointed out, with the warnings on every pack of cigarettes that he smoked. Another thing that the plaintiff pointed to was Mr. Gordon's testimony that he didn't know that that smoking could cause COPD. But there was evidence that was presented at trial that for decades, there was a rotational warning on cigarette packs that specifically warned that smoking could cause emphysema, the very disease that he received. His emphysema is a form of COPD. So that was the testimony that the plaintiff pointed to. When we moved for a directed verdict on this issue, the trial court did not orally from the bench or in any written format discuss the failure to warn issue, so we don't know why the trial court.
Just denied it without comment.
Exactly, yes, Your Honor. Yes, and I'm happy to address the design defect issue as well, or I'm happy to go back to Chief Judge Rowe, your question about preservation on the jury selection issues.
Let's move on to the design defect
Okay.
unless Judge Long has questions about the jury selection.
I don't.
Okay.
Okay. So I don't think there's any dispute on the law here. Mr. Gordon had to prove that a defect in cigarettes caused the injury that he caused his smoking-related injury. And he can't prevail under a theory that all cigarettes are inherently defective. That's consistent with Judge Thomas's opinion in Whitney. There, the court pointed out that there were defects, like filters were one of the defects in Whitney, and the defect was lights or low tar. So there were ways that cigarettes were modified and changed to make them more addictive.
Again,
Here-
regardless of what we said in Whitney, under Gooding, and the plaintiff had to show 50% plus 1 iota of evidence that it was but for the smoking of the cigarettes, he would have had COPD by 1969, if the failure to warn claim fails.
That's exactly right.
Well, let me do something here I occasionally do with lawyers at oral argument, and it's It's called the Allen charge from trials. But sometimes jurors are instructed to not adhere to their own position, but acknowledge the evidence on the other side of their view. Put yourself in the position of appellee if you can. I know it's not easy. What evidence is there to show that an expert said that?
There's absolutely none, Your Honor. I can't think of any.
I didn't see it in the appellee's brief either. I didn't see any discussion of but-for causation.
That's exactly right. The only evidence that the plaintiff pointed to in their brief was evidence that addiction caused Mr. Gordon's COPD. They didn't point to any evidence that the defects that they alleged, which here were inhalability and nicotine manipulation, and I'm happy to walk through each of those alleged defects. They didn't point to any evidence that those defects caused addiction. So there's just a fundamental gap in the evidence here between the alleged defects and the smoking-related injury. There's no evidence that would satisfy that but-for standard here.
I mean,
And
all cigarettes were inhalable, right?
That's exactly right, Your
That's the whole
Honor.
point of a cigarette.
Exactly right, Your Honor. Inhalability is a fundamental attribute of a cigarette. In fact, the plaintiff's own expert, Dr. Proctor, said precisely that. He testified a fundamental difference between a cigarette and a cigar is that you inhale a cigarette and you don't inhale a cigar. So while you could make a product that looks like a cigarette but is non-inhalable, according to the plaintiff's own expert's definition, that would be a fundamentally different product. It would be a cigar.
And how do our courts and juries supposed to sort out this issue of, it seems that the cigarettes here were designed to do exactly what RJR wanted them to do, to be more addictive, to be more inhalable. How do you sort out what is a feature of the design and a defect in these types of claims?
I think the way that you could look at that is say, can we take out that defect, the alleged defect, and is it still the product?
But I want to go back to, is it even a defect if it's designed for that exact purpose, to be more inhalable, to be more addictive?
I don't think it is. And here the jury was instructed on the consumer expectation test for design defect, which is a standard set forth in Aubin. And under the consumer expectation test, the product has to perform differently than consumers would expect. And the testimony here from plaintiff's expert was that all cigarettes are inhalable. And in fact, we asked Mr. Gordon, we said, if you picked up a pack of Winston cigarettes and you couldn't inhale them, what would you think? And he said, I would think that there was something wrong with those cigarettes. So under the consumer expectation test, which the jury was asked to apply here, this simply is not a defect because it's exactly the way that consumers expect them to perform, exactly as Your Honor mentioned.
And let's just assume for argument's sake that there is a defect. Judge Thomas's question is there any but-for evidence to show that portion of the cigarette design was what caused the COPD in this case, as opposed to just cigarette smoking, inhalable smoking in general?
No, not at all. So there are two alleged defects. One is inhalability. As we discussed, that's actually not a defect, so it can't be the defect that caused his COPD because it's just not a defect. The second one was nicotine manipulation. There was no evidence that there was evidence about nicotine manipulation, but there was no evidence connecting that to addiction. There was no testimony that, if Reynolds had made cigarettes a little bit with lower nicotine levels, then they would have been less addictive and Mr. Gordon would not have gotten his COPD. In fact, we asked the plaintiff's expert this, and he specifically said that there is no threshold level of nicotine that creates or sustains addiction. That's on page 866 of the trial transcript. And what he meant when he said that is that he couldn't identify a level of nicotine below which cigarettes would be any less addictive or less likely to cause COPD. So we just have a total failure of proof on the causation element of this design defect claim.
And as to this plaintiff, whatever the nicotine manipulation, he'd smoked for 15 years before 1969 and decades after, correct?
That's absolutely correct, yeah. Yes, Your Honor. I'll just briefly go back to the question that you asked at the beginning about the jury selection issues and about preservation, because you asked about the Joyner issue, about preserving the errors right before the jury was sworn. And the point that I wanted to make there is that we did object right before, at the very end of jury selection. And so, as the Florida Supreme Court explained in the Joyner opinion, The concern is that, if an objection is made perhaps in the middle of a jury selection or at the beginning, the court might reasonably believe that by the end of all the striking process, the lawyers are satisfied with the final composition of the jury, and that's why counsel needs to renew their objection. Here, the very last juror that was seated on the jury, we objected to that juror, and so there was no question that Reynolds was unsatisfied with the composition of the jury.
But it's fair to say that Reynolds didn't lay out the very broad arguments that are in your brief about the process, itself, that it was too short in time. You weren't able to adequately, review a number of jurors, not just this one juror. It seems to be a broader argument that we're looking at on appeal.
I don't know that that's quite right. I would point your honor to page 471 of the trial transcript. There, Reynolds does set forth basically the exact same argument that we're making here. They said, we believe we are entitled to speak to each juror that could end up on the jury. Because of the restraints on our jury selection, we weren't able to speak to 5 prospective jurors at all, and then ask the court to dismiss those 5 jurors. So I do think they made the exact argument that we're making here today. If there are other questions, I'm happy to answer them. Otherwise, I can reserve the rest of my time for rebuttal.
Thank you, counsel.
Thank you.
Good morning. May it please the court. Michael Teen for the appellee. It's my first time before your honors in this courthouse. It's my privilege to appear in front of you. Would your honors like me to start with the jury issue first? As for the jury issue, I respectfully frame it differently. I think it's a matter of invited error. I think if your honors...
Yeah, assuming we agree with you on the jury issue.
Okay.
Assuming we agree with you on the jury issue, could you address the directed verdict issues?
Yes, Your Honor. So I think that we're focusing perhaps unduly on the labels themselves as the warning. The evidence was that in the initial period that Your Honor identified before the warnings were put on, that, well, let me start first. It was a negligence claim. It wasn't only a failure to warn. It was the negligence claim itself, in addition to the count for products liability. One of the theories was failure to warn, and the other was ordinary negligence, as the jury was instructed. And our position, Your Honors, is that regardless of the failure to warn, R.J. Reynolds was negligent during that initial period because they affirmatively knew that they were making a deadly cigarette, and that they did not inform the public, and so they violated their duty of care in that regard. Specifically drilling down on, Your Honor, Judge Thomas's question, I respectfully frame the issue slightly differently, which is not whether his COPD was caused during that initial period, but it's rather did he become addicted to the cigarettes? And that was what the proof was at trial. We did read in the deposition testimony of Dr. Drobes, David Drobes, who was the addiction expert, and he did testify about the addictive nature of cigarettes and his conclusion that the plaintiff had become addicted to cigarettes early on. So respectfully, it isn't that the COPD itself might have been contracted during that initial period. You're correct, counsel is correct, that wasn't the testimony, but that wasn't our theory either. It was that he became addicted during this initial period, and that addiction continued on.
Well, I assume he did become addicted, and smoking can be very addictive. But aren't you obligated to prove that the addiction caused an injury?
Yes, and so it was the addiction, and the plaintiff did testify to that. He testified about his habits and his inability to put down the cigarettes. He testified about how much he suffered from the addiction, and that he lit the cigarette the first moment that he got up on his way to the restroom. He smoked this last thing he did before going to bed, getting up in the middle of the night, that type of addictive behavior. So as to the failure to warn, it's not just about the labels. It's about failure to warn generally. This particular plaintiff had a very, very basic education. 6th grade was the testimony. He worked in the tobacco fields initially growing up, and then later as a employee farmer. He had very little education. There is the idea that if someone is not able to read or understand warnings, that they couldn't bring a failure to warn claim is an interesting question, but I don't think it's properly before this court. I think that this gentleman testified that had he understood that cigarettes were deadly, that he wouldn't have smoked them. That was clearly his testimony, and I do believe that puts it over the 50.001 threshold. But it's important, very important for me to clarify that the evidence was not, most respectfully, that the definition of a cigarette was that it's inhalable. The definition that was presented by the expert, Robert Proctor, our first witness, was that the definition of a cigarette is tobacco rolled in paper. And the testimony that he gave was that the defect itself, which is, Chief Judge Rowe, not inherent in the design, is that the cigarettes were made inhalable by R.J. Reynolds because of the type of curing process that flue curing that isn't used in cigars, but is used in the cigarettes that they make, and that inhalability itself isn't an inherent design element of cigarettes. And I think that's an important distinction because they footnote it, and they repeated it again here, but that wasn't it wasn't the evidence that a cigarette is inhalable. The evidence was that a cigarette is tobacco rolled in paper.
But at least for RJR cigarette, it was inherent in their design, and it was intentional in their design, correct? That it wasn't an
Yes,
afterthought. They intended to make design these cigarettes with these features.
Yes, so that the cigarettes would be more addictive, and that they would addict consumers, and then all the while knowing from 1954 forward, and the plaintiff started smoking. The testimony was right around 1954 when the initial warning was, the initial false statement was put out, the frank statement to smokers that was put out in thousands of newspapers and magazines across the country, saying that R.J. Reynolds saying that if they found a defect in their cigarettes that was harmful to the health of their consumers, that they would advise the public, when in fact that was not the case. And I won't bore your honors with the litany of that, but that was very clearly the testimony, and the repeated misleading of the public as to the truth about the addictiveness and about the deadliness of cigarettes during that period and afterwards. So while if they knowingly put that defect in, that still can be a design defect, and that was the testimony, that in fact inhalability was one of the defects.
Well, what's the line that separates the fraudulent concealment claim when a manufacturer, intentionally designs a product as this one was designed? It wasn't a defect in the way they intended to design this product as much as it may be, as you're saying, something that was intentional but concealed from the consumer. What's the line between these two causes of action?
Well, we abandoned the fraudulent concealment and conspiracy claims before trial. So
right.
We unusually, I guess for these cases, we only tried it on products liability and negligence. Mm-hmm. So I think the answer to your Honor's question is that fraudulent concealment is not just concealment of the defect itself, which here wasn't concealed in that it was inhalable. That was obvious. The concealment was of the truth. And so had we brought a fraudulent concealment claim, we would have had to prove that there were affirmative statements or omissions relied upon by the plaintiff. Right. I think that's what distinguishes it in the
right. Under our Whitmire case, right?
Yes.
So, Correct.
Absolutely, and Whitmire makes that very clear. So we narrowed the case. When we had a plaintiff here who, I don't want to say he was, I won't say that he was illiterate or functionally illiterate, but he did testify that he didn't look at the warnings, but he also clearly at the labels warnings, but he also clearly testified that he was very risk averse and that he didn't ride motorcycles, he didn't have a firearm, he didn't fill up a car with the engine running, all those very conservative types of behavior, such that he said, had I known in whatever fashion, and there were other ways that they communicated with consumers generally and to him, other than just the warnings on the packs. And again, not saying that the warnings could have been better after 1969, but there were other ways to warn consumers prior to that period other than words on the pack. You could have put a skull and crossbones on the pack. You could have written poison, well, both of those.
That kind of argument's preempted by federal law, right?
After 1969.
Right.
But
They had no legal obligation to put a skull and crossbones on the package.
No, they did not. But prior to 1969, my point only is that focusing.
But again, I appreciate your argument about prior to 69, and I don't mean to diminish your argument, but can you show me where your expert testified that he contracted COPD by 1969 based on a but-for causation analysis?
No, I can't.
And isn't that fatal to your lawsuit?
No, for two reasons. One, we had a design defect claim, and that design defect continued after 1969. But even if you look at just the negligence claim, like I said, first, as to Your Honor's focus on what the disease was, I think that the analysis isn't did he get COPD in that period? It's did he become addicted, which was ultimately led to his COPD. And the evidence was that he did become addicted during that period, that he immediately got up to smoking 1 to 1.5 packs a day, which Dr. Drobes, the deposition testimony that was read in, indicated to Dr. Drobes that the plaintiff was addicted. Even if Your Honor's correct, let's just say Your Honor's correct, and I don't think that would apply to the design defect claim because that isn't dependent on warnings or any other type of analysis. I have a few minutes left. I would respectfully like to just speak briefly about the juror issue if Your Honors want to hear. Otherwise,
I don't, but I can't speak for my colleagues.
I don't have any questions about it.
I'm sorry?
I don't have any questions on it.
And I have no questions.
Well, then if I'm here if there's any other questions about anything else, but other than that, I would ask that the judgment of the trial court below be affirmed.
Thank you, counsel.
So what do you say about that? Your learned opponent's argument that he was addicted, the addiction lasted his whole adult life. He obviously did contract COPD. It was diagnosed in 2018, as I recall. And that is the basis of the negligence claim.
A few points on that. First, it was the plaintiff's burden to prove that the failure to warn before 1969 caused Mr. Gordon's COPD. The plaintiff is saying we can satisfy that by showing that he was addicted before 1969, but there's a few reasons that argument doesn't work. The first is that addiction did not change Mr. Gordon's attention span. He repeatedly testified that he did not pay attention to the warnings that he received on every single pack of cigarettes after 1969. there's nothing about being addicted that changes the ability of a person. The plaintiff is not arguing that Mr. Gordon could not read. He did not testify that. He testified that he, in fact, did read the warnings. He just didn't pay attention to them. He didn't care about it. Safety of cigarettes was not something he was concerned about. So addiction did not change his attention span. The burden is on Mr. Gordon to show that he would have treated a pre-69 warning differently than the way that we know he treated a post-69 warning. And there's no evidence of that here. Well, addiction may have caused Mr. Gordon's COPD. There's no proof that Reynolds' failure to warn before 1969 or even a design defect caused his addiction. And that's why this argument about addiction causing the disease, that doesn't connect it to the failure to warn or the design defect.
But what about the argument that it was a general verdict, and thus, because you can't distinguish between failure to warn and design defect, that the plaintiff or the appellee prevails under either theory? What I'm asking you to do is, again, is sort of an Allen charge to you. Tell us why being addicted to cigarettes, which eventually results in COPD, does not support the negligence verdict.
On the design defect aspect, because there's no evidence that the only viable defect, which is nicotine manipulation, led to addiction. They need to connect the defect to addiction.
So your argument is there was no expert testifying that but for the design defect, he would not have been addicted?
That's correct. So inhalability, as we discussed, is not a viable defect because it's not a defect at all. But as to nicotine manipulation, there was no evidence that if nicotine levels were slightly lower or were at a certain level, that Mr. Gordon would not have become addicted and then would not have.
So is it the crucial aspect then that they had to present expert testimony that a lower nicotine level in the cigarette would not have resulted in COPD, that but for the higher level?
That's
50%
exactly-
plus 1 iota?
That's exactly right. They would have to present some evidence that the defect, nicotine manipulation, actually led to addiction. And if you just point to evidence that, look, tobacco companies are changing the levels of nicotine, that doesn't say anything about addiction. They need to connect that to addiction. And the way that they do that, and there are experts that testify as to this in other cases, is present testimony that if the nicotine levels were below a certain threshold, they would not lead to addiction, and Mr. Gordon wouldn't have gotten his COPD. That's the evidence that's missing here. There's no evidence connecting the alleged defect of nicotine manipulation to addiction and therefore to Mr. Gordon's COPD.
And had there been such evidence, you would concede that the directed verdict should have been denied?
At least on the grounds of nicotine manipulation. Yes. I did just want to point out one other thing to the court. Dr. Reed testified that Mr. Gordon's COPD began developing at the earliest in 1998, and that's at page 1404 and 1406 of the trial transcript. So we have testimony from the plaintiff's expert. The only testimony was that his COPD did not begin developing until at the earliest 1998. So there's nothing connecting it to that pre-69 time period. Thank you.
Okay. Thank you, counsel. Thank you all. We will take a brief recess.
Thank you, Robert.